Welcome to our deep dive on family loans and bankruptcy. In this video, we will explore what happens when a parent files for bankruptcy and there is a loan involving their child, especially if the loan originated when the child was a minor. We will cover legal basics, documentation, repayment timing, trustee perspectives, and practical action steps. We will also clarify common misconceptions, highlight potential pitfalls, and provide a structured plan to reduce risk. Let's begin by outlining what we will cover, and then move into a short disclaimer to set expectations. This topic matters because the intersection of family ethics and insolvency law can create confusion and unexpected consequences. If handled incorrectly, both the parent and the young adult can face additional scrutiny and stress. To ease into the topic smoothly, we'll first look at today's agenda, and then move into a clear disclaimer about legal advice. Today's agenda includes understanding minor contracts and law, how trustees classify interfamily debts, whether a family loan's repayment schedule changes during bankruptcy, what documentation matters, how to think about preference payments, and a step-by-step action plan. We will also include short quizzes to reinforce learning before we summarize key takeaways. Before we continue, please note this is educational content and not legal advice. Bankruptcy and contract rules vary by state and country. You should consult a qualified bankruptcy attorney who can review your specific facts, including your state's laws on minor contracts and debt enforceability. Our examples are simplified to help you understand the core ideas. Let's establish the legal foundation. Contracts signed by minors are typically voidable or unenforceable, which means a young adult who borrowed before turning 18 may not be legally bound in the same way an adult would be. This is why the borrower's liability is often questionable. From a trustee's perspective, interfamily loans lacking documentation frequently look like gifts, not debts. This classification can reduce pressure on the young adult but complicate the parent's asset reporting. Regarding timing, the parent's bankruptcy does not automatically accelerate a reasonable, documented repayment schedule. If a 5-year plan was made in good faith, trustees generally cannot demand immediate full payment. However, all of this is highly dependent on jurisdictional rules, so consulting a local attorney is critical. With these basics in mind, let's visualize the decision points in a flowchart next. This flowchart shows the typical decision path. First, determine whether the borrower was a minor at the time of the agreement. If so, the agreement is often voidable or unenforceable. Then consider whether the borrower later ratified the agreement after turning 18. Such as through a new written acknowledgement or executing payments under updated adult terms. Without ratification, it remains likely unenforceable. If ratified, the next question is documentation, a promissory note, a clear repayment schedule, and bank transfer records. That documentation, trustees often reclassify the transaction as a gift. With solid documentation, ask if the terms are reasonable and aligned with actual payments. Reasonable, consistent terms tend to be respected, so the trustee is less likely to accelerate payment. If terms are irregular or unusually favorable, expect more scrutiny and a higher chance of reclassification. Documentation makes or breaks interfamily debt. Use a promissory note specifying principal, interest if any, repayment schedule, and default conditions. Make repayments with traceable instruments like checks or dated bank transfers. Maintain a ledger of all payments with corresponding receipts. Avoid cash and unclear payment memos. If the borrower turned 18 and terms changed, update the documents to reflect a ratified adult agreement. Strong documentation protects against reclassification as a gift. Here is a practical action plan. First, both the parent and the borrowing adult should speak with a bankruptcy attorney. Second, gather all documentation, including the promissory note, bank statements, and payment ledger. Third, consider whether to pause repayments during the filing. This decision should be made on counsel's advice. If you pause, document the date and the reason. Resume payments only when counsel approves to avoid preference risks. Finally, create a written timeline of the loan and all repayments to clarify the sequence of events. Quiz time. The question is, if a young adult borrowed from a parent before turning 18, how is the contract typically treated? The options are 1. Fully enforceable like any adult contract. 2. Voidable or unenforceable in many jurisdictions. 3. Automatically forgiven if the parent files bankruptcy. Or 4. Converted into a court judgment by the trustee. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is voidable or unenforceable in many jurisdictions. This is due to the general principle that contracts signed by minors are not enforced in the same way as adult contracts. Without later ratification and strong documentation, trustees may treat the arrangement as a gift. On the left, a documented loan includes a promissory note with explicit terms, traceable payments, and a consistent schedule. This lowers the risk that a trustee will reclassify the transaction as a gift. On the right, an undocumented arrangement relies on informal promises, cash payments, vague memos, and irregular timing. Those factors raise the probability that a trustee will treat the transfers as gifts rather than enforceable debt. This table compares common scenarios. When there is a 5-year plan and the parent files in year 2, with strong documentation, the plan is usually respected and not accelerated. Informal transfers without a promissory note invite reclassification as a gift. Payments made in the 90 days before filing may be treated as preference payments and could be clawed back. If an attorney advises pausing payments during filing, documenting the pause can reduce preference risk. This timeline illustrates a typical sequence. At year 0, the loan is created when the child is a minor. In year 1, some payments are made via bank transfer. In year 2, the child turns 18 and may ratify the agreement through an updated note. Around month 30, the parent considers bankruptcy, consults an attorney, and may pause payments. At month 33, the bankruptcy is filed, and the trustee reviews the documentation and any payments in the prior 90 days. After month 36, payments may resume if counsel advises, and the original schedule may continue if respected by the trustee. Preference payments are transfers made close to the bankruptcy filing that may unfairly favor one creditor over others. Trustees often review the 90 days prior to filing to identify such payments and may seek to claw them back. An attorney may advise the borrower to pause repayments during the filing period to prevent creating a preference. Maintaining meticulous records of all transfers helps rebut allegations of preference or fraud. Resuming payment should be done only after the attorney confirms it is appropriate. Here is the second quiz. The question is, during the parent's bankruptcy process, what is often the safest approach regarding ongoing repayments from the child? The options are 1. Continue paying as usual to show good faith. 2. Increase payments to finish the loan early. 3. Temporarily pause repayments if advised by counsel. Or 4. Convert the loan to a gift immediately. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is to temporarily pause repayments if advised by counsel. This approach helps avoid creating preference payments that a trustee might later attempt to claw back. The decision and documentation should be made under the advice of a qualified bankruptcy attorney. Key takeaways. Agreements signed when the borrower was a minor are often voidable, which can protect the young adult. Strong documentation is critical to avoid reclassification as a gift. Bankruptcy does not automatically accelerate a reasonable, documented repayment schedule. To avoid preference risk, consider pausing payments if advised by counsel. Both the parent and the borrower should consult attorneys early in the process. To recap, contracts signed by minors are frequently voidable, making young adult liability uncertain. Trustees focus on documentation quality, reasonableness of terms, and payment timing. A legitimate, documented schedule is generally not automatically accelerated by a parent's bankruptcy. Your action plan includes consulting counsel for both parties, gathering documents, pausing if advised, and maintaining a clear timeline ledger. Thank you for watching. If this was helpful, please like, share, and subscribe. Tell us your experiences or questions in the comments so we can cover them in future videos. See you next time.